Hello, everyone. Thank you for joining us today. Today is February 15, 2023, and we are starting our program Momento Brazil with Canal Arbitragem, and we thank Canal Arbitragem for the partnership with the CIArb Brazil Branch in presenting this program that is coordinated by me, Cristina Mastrobuono, and also Cesar Pereira, our former president. I also want to thank FBonassa Advogados for being our sponsor in this program. Well, today we have a very interesting participation of Ana Gerdau de Borja Mercereau and Noreen Kidunduhu. We aim to explore the views of arbitration in two different continents, Europe and Africa. I will make a brief introduction. Dr. Ana Gerdau de Borja Mercereau is a fellow of the Charter Institute, a senior associate at the Reins and Garavi. She has over 13 years of experience in domestic and international arbitration and holds a PhD and an LLM from the University of Cambridge. She acted as counsel, arbitrator, and secretary to arbitral tribunals in arbitrations under the worldwide most important arbitration institution rules. Her cases have included commercial transactions, joint ventures, large infrastructure projects, M&A deals, and projects in real estate and for mining research and exploration. She's a member of the ICC Commission on International Arbitration in ADR in the task force entitled Corruption in International Arbitration and co-coordinator of Track 5 of the same task force. Ana is one of the founders of the Rising Arbitrators Initiative and co-chair of its executive committee and of DELO's Long View Steering Committee. And she's a former deputy chair of the Charter Institute's Young Member Group, Global Steering Committee. Noreen is based in Nairobi, Kenya, and is a member of the Charter Institute of Arbitrators. She's a common law qualified lawyer who routinely represents clients in both institutional and ad hoc arbitrations under a wide variety of arbitral rules. She has also appeared in court matters related to arbitration. She holds a master's degree in international energy law and policy from the University of Dundee and was in the inaugural cohort of the Africa Arbitration Academy. Noreen is the immediate former chair of the Charter Institute of Arbitrators Young Members Group, Global Steering Committee. Since her admission to the Kenyan bar, Noreen has been a member of the Law Society of Kenya's Alternative Dispute Resolution Committee, during which she has actively participated in supporting the development of arbitration in Kenya. And she was recently recognized as one of Africa's 30 most promising young arbitrators by the Association of Young Arbitrators. So thank you very much for being here, Noreen and Ana and Cesar, for coordinating this program with me. And without further ado, I will start with the questions. And I ask first Noreen. Noreen, you are a lawyer in Kenya, and your main field of work is related to energy and natural resources, including environmental issues. You take part in the Energy Charter Secretariat, reviewing investment climate and market structure of the energy sector of various countries. What can you tell us about this area in your country?
Thank you, Cristina, and thank you for having me to have this discussion. And just to answer your question about the energy sort of system and sector in Kenya. So we are a unique country in the sense that, unlike other African countries, most of our electricity is renewable. So currently between 10 p.m. and 6 a.m. in Kenya today, all the electricity that is generated is actually renewable. And then during the day, about 90% of the electricity that we use is renewable as well. So in a sense, unlike other African countries, we're not struggling with the issue of the energy transition or greening our grid, because our grid is already largely green. What the discussions that we are having currently in the country are on how to decarbonize the other sectors of our economy. So we are looking at how to decarbonize our transport system, how to decarbonize our cooking, our industry, our manufacturing, and so on. So the government priorities currently are on putting in place policies and incentives that will drive the demand and uptake of e-mobility, for instance, e-cooking. We have programs that are supposed to promote energy efficiency and in green buildings particularly. We are having currently feasibility studies on using green hydrogen as an alternative energy source, as well as using LNG instead of heavy fuel oil for power generation. So, I mean, that's the kind of discussion that we are having in Kenya. We have already sort of greened our grid, and so what we are looking at is decarbonizing the other sectors of our economy.
Oh, very interesting. And when you say it's already a green grid, and it's renewable energy, does it come from water power or solar energy? Is solar energy also explored?
So it's a huge mix. We have hydro, we have geothermal, we have wind, and we have solar. So our mix is mixed between those energy sources.
Very nice. So now turning to Anna. Anna, you are now for 8 years practicing arbitration in big law firms in Paris with cases around the world. What can you tell us about the main concerns in arbitral proceedings nowadays, in your point of view?
Thank you for having me. Thank you for the invitation. It's an honor to participate in this program. Yes, so to answer your question, Cristina, I was lucky to study at the University of Cambridge and to have splendid mentors there. I should mention that the late James Crawford, who was the supervisor of my PhD thesis and with whom I learned very much, was key to my understanding of, I would say, not the British way, but the Anglo-Saxon way, because he was not British, he was Australian. Also, my director of studies at Cambridge was South African, Alan Dashwood. And I would say that perhaps the Anglo-Saxon way would be, in terms of legal aspect of the Anglo-Saxon way, and also arbitration, I would say there is an extreme attention to language, and with a special focus on the simplicity of language. To be concise is an art and more difficult than to write in lengthy ways with the use of adjectives and adverbs. So perhaps concision and economy of language is a key, and that I've learned with them. And the choice of each word and expression is also very important. I recall Crawford introducing me to the book Fowler's on the Use of the English Language, which he used to go through every now and then, a few times a day. I thought it was a bit obsessive, but it's part of the Anglo-Saxon way, in a way that language and each word is very important. I practice mostly in English, but also in Spanish, Portuguese, and French. And when it comes to arbitration, it is true that now I'm practicing in Paris, not in the UK. And it's true that Paris is perhaps the mecca of arbitration, if one can say that, and put it that way. The level of sophistication of discussions involving arbitration is extremely high, I find, in Paris. Also, as you know, French law is extremely favorable to arbitration, although it is said to be changing a little when it comes to the control of public policy, international public policy, with decisions related to, for instance, corruption, not corruption of arbitrators, but corruption related to allegations of corruption in arbitration. And sometimes what the last decisions or the most recent decisions of French courts, they would go so far as to accept new evidence in proceedings for setting aside proceedings or commission and enforcement proceedings, and would go and sort of review the merits with respect to those allegations of corruption again, in a way, even if one of the parties has not raised corruption during the arbitral proceedings. So this is an important development that has been, to a certain extent, criticized by French practitioners. This is French court development, not necessarily representing the idea or the vision of French arbitration practitioners. And to say, I mean, the differences, perhaps I wouldn't say there is a big difference in the terms of how we practice arbitration, because as you know, in international arbitration, it's become a bit uniformized in a way. So I would find that we practicing in London or in Paris or in New York or in Geneva, in international proceedings, I'm not speaking for domestic proceedings, then it's a little bit different depending on the country. But yes, I wouldn't see any much of a difference, except for one thing that I find that sometimes happens in cases involving Anglo-Saxon practitioners, is that sometimes they use barristers to do oral pleadings, to participate in the hearing. So a solicitor does most of the case, and then suddenly, just before the hearing, they appoint an additional counsel to do the pleadings. That I've seen, but not often. I mean, sometimes it may happen.
Okay, thank you very much. Cesar, I will hand it over to you.
Thank you, Cristina, and especially for the partnership in the organization and in the the work related to this CIArb Moment at Arbitration Channel. And before we move on, I would like just to quickly ask Ana a follow-up question on what you just said. I believe you are referring to the so-called Alstom saga, right? The recent decisions regarding corruption and public policy. But do you just very quickly, do you see that as a trend, as something that represents how French courts see allegations of corruption in arbitration, or issues relating to corruption in arbitration, or is that maybe an outlier? Is that a case that does not represent, let's say, a French approach to that issue?
Yes, it's difficult to say. There have been a few decisions, not only on the Alstom case, but especially also on the Belocon case that relates to investment arbitration. But nevertheless, I mean, in the end, the logic is the same with respect to allegations of corruption. I see that there is a current trend. I'm not sure whether this will remain or persist in the future to come. It is difficult to predict, but it's been very much criticized, and some colleagues French colleagues of mine said, "Oh, maybe I will not propose that Paris is the seat of arbitration for my clients because of this risk." But at some point, I mean, at the same time, to have a clean arbitration without corruption, I think it's good. So when it comes to corruption, I don't think it's the only problem with the approach that was taken by the Paris Court of Appeal and the Cour de Cassation is that they that was confirmed by the Cour de Cassation is that they review the merits again in this respect, and also even if the party hasn't raised it, and maybe for French lawyers it's a bit shocking, because normally there's the loyalty, like procedural loyalty, that you have to, I mean, you can't just take something out of your hat in later on, you know. It's difficult to say whether this will persist, to answer your question. Yeah.
Thank you, Ana. And Noreen, turning to you, I'd like to ask you a question about the status and the developments of arbitration in Kenya. are arbitration agreements used in all sorts of contracts or mostly in international deals only? For another issue, are state entities allowed to use arbitration? How do you see Kenya in the context of other African countries in this regard? I understand countries such as Nigeria and Zambia, for instance, are very active in the submission of state parties to commercial arbitration. And so how do you see Kenya in that context?
Yeah, thanks for the question. Just to, to set sort of the background. So we promulgated a new constitution in 2010, which made ADR a constitutional imperative. So between 2010 and now, we've seen, of course, the uptick of mostly ADR alongside, our judicial system. And for example, our judiciary has been very keen to uphold arbitration agreements, but also to enforce awards that have been brought to Kenya for enforcement. But the judiciary has also developed court-annexed mediation, which basically when cases are filed in our courts, they are screened to confirm that they can be mediated. And if they can, they are sent to a court-accredited mediator for mediation within 60 days. If they do not reach a settlement, then the matter now goes into the court system. So we can see that the judiciary in Kenya is open and agreeable to ADR mechanisms. But beyond that, we have seen, the growth of international commercial arbitration, as well as domestic arbitration in the region. We have now a Nairobi Center of International Arbitration that sits in Nairobi and takes up international arbitration matters. We have a CIArb branch, Kenya here, which of course undertakes trainings, but also appoints arbitrators from the region to take up domestic arbitration. So we've seen that as well. And across the continent, we are also seeing an uptick of arbitration generally. We've seen countries like Nigeria, country like Sierra Leone amending and revising their framework for arbitration. We've also seen the mushrooming of arbitral institutions. There are currently 91 arbitral institutions in the African continent. Of course, the main ones are in Cairo, the one in Rwanda, Mauritius, the Common Court of Justice and Arbitration for the OHADA region as well. So that already shows that there's an uptick of arbitration in the region. But when it comes to framework as well, we can see like the Africa Continental Free Trade Agreement puts in place mechanisms for resolution of interstate disputes through arbitration. And SOAR also had a study last year that showed that many African respondents said that they have a bias for dispute resolution and particularly arbitration for inter-African disputes. So the continent is very open and willing to take up arbitration in the space. And I don't know if you're aware, also the Africa Arbitration Academy developed a model BIT for African countries, which of course enshrines arbitration as well. So across domestic and international arbitration, we can see frameworks being put in place. We can see institutions coming up and rules, and of course model BITs that enshrine arbitration in the African space.
Thank you, Noreen. I just to your last point there, my understanding from what you said is that when states are involved, the focus is basically treaty-based arbitration, right? BITs and the Inter-African initiative, it is also related to treaty arbitration, not commercial contract-based arbitration. Is that correct?
That's correct. But not to say that arbitration is not also being adopted by commercial parties. So a lot of the contracts right now, because of the foreign direct investment coming in, and parties that, of course, are either registered or have registered companies here, we see there's a lot of international commercial arbitration that is also happening, but also most domestic commercial contracts also just have arbitration agreements within them. So a lot of the dispute resolution clauses that we are seeing in contracts right now are promote arbitration.
Thank you. And Anna, back to you now. I understand you have a lot of experience in infrastructure contracts, and so from the cases you have been involved with, can you maybe point out some of the main reasons for disagreement between parties in an infrastructure contract? Can you say whether there are different interpretations of the contract, or contracts should be drafted better? Do you think there should be maybe a greater interaction between litigation lawyers and transactional lawyers to prevent future damage disputes? So how do you see that in your practice?
Thank you for that's a good question. I would see as the main reason for disagreement in infrastructure dispute as being often lack of communication between the parties, or poor communication, and as you mentioned, poorly drafted or unclear contractual provisions. Also, sometimes disagreement comes from a party, let's say, no longer having interest in the transaction for commercial reasons. For instance, there might be political changes or currency fluctuations that make that the contract makes no sense in terms of what was the price and what was agreed on. So it can vary, but what I see is this normally.
Thank you. And I think it's interesting that you mentioned as the first reason the lack of communication. And do you see a growth in the use and the effectiveness of mechanisms such as dispute boards or mediation in infrastructure contracts? Those are generally thought of as forms of enhancing communication and maybe preventing problems like the ones you mentioned.
Yes, well, as you mentioned in the question, of course, first, when drafting the contract, of course, if there's a good interaction between transactional lawyers and dispute lawyers, they might come to more precise and less ambiguous terms. But then, of course, when the contract has already been concluded, then I would say that what I see for infrastructure, especially because these are often long-term contracts, I find that more than mediation, actually, dispute boards would be very suited, especially because, well, I would the type of dispute boards that are standing dispute boards, not the ones that are set up later on during the life of the contract, but those that already they are set up just after the contract is concluded, and then they will be deciding on the smaller disputes au fur et à mesure, as they say in French, like during the life of the contract, so that it doesn't become a snowball. What we say in Portuguese, that's an expression. So they and what I see from the statistics is that very often the disputes are solved, I mean, by way of the recommendations or dispute board decisions, and there is no arbitration. So it prevents going so far as arbitration. And finally, probably it's a more efficient way for long-term infrastructure contracts.
Thank you.
Yeah,
Thank you. That's very enlightening. Oh, please, Noreen, go ahead.
No, I just wanted to chime in. So what I've seen on our end, other than, the dispute boards and the mediation pre-arbitration, is sort of expert determination, so that the matters that can just be taken to the expert go to the expert, and then if they disagree, then finally we have arbitration. But also having those multi-tiered dispute resolution clauses where you negotiate first, or there's mediation between the CEOs of the companies before finally we go to arbitration. But I found it very interesting, Anna, that lack of communication is actually a big issue in those types of contracts.
In Noreen, since you gave us this information now, is adjudication a common form of dispute resolution in Kenya? Do you follow the, let's say, the UK tradition of adjudication in construction contracts, which is not present in many other countries. Do you do adjudication as well?
Yeah, it's now becoming common in our larger infrastructure projects to have adjudication. But for the domestic sort of infrastructure projects, we have our own sort of, it's called the Joint Bidders Council. It's a template contract that usually provides for arbitration, but before the arbitration, it provides for negotiations or sort of mediation between the parties, which if it fails, then now you proceed to arbitration.
Okay, thank you. Cristina, back to you. Thanks.
Yes, I just want to comment quickly about what Anna said. So the lack of communication between parties, and I can give my experience of being in a dispute board, that it really helps in this sense of being a monthly forum or every 2 months where parties sit together and the dispute members, they ask what's going on, is there a dispute arising, is there something you are not agreeing upon? And well, my experience so far is that it's really a good tool to be used in these long-term contracts. But what you said, not the ad hoc dispute board, but the one that's from the beginning on, and I think it's very useful. But anyway, Noreen, I would love to go back to the energy matters to discuss with you, but since time is short, and you are the former chair of the Young Member Committee of the Charter Institute, I want to hear your thoughts about that, to know how was it to be in this position? What's your experience in that?
Yeah, first I have to say I was very lucky to have Anna as my deputy, because we sort of created a symbiotic relationship that we leverage on our strengths, on each other's strengths. So, you know, Anna is very detail oriented. I'm a person of the larger picture. So we work very well together, and it was a beautiful experience to have with her. But in terms of what we needed to do, it was both challenging and gratifying. I remember one of the first issues Anna and I had to deal with was at the cusp of the Ukraine and Russian war, and it was whether to involve our Russian counterparts and members in our activities. And it was quite a decision that we had to make, and we had to do, you know, back and forth calls and involve everyone in the committee to just understand how best to deal with that situation. But also we found ourselves in what I can call the new era of the committee, because for the first time ever, we had the largest diversity in terms of our members. And it was also the largest committee. So about 18 of us from virtually every continent. And so it was the first time that we had that kind of committee. And because of that, we needed to put in systems in place that would, you know, take into account that sort of diversity and that number. And all the ideas that came with. Before that, we didn't actually have structures, basically because the committee was very small, but also because we were also in a particular region. So some of the things that we managed to do with Anna is finalize the revision of the rules. So now the YMG steering committee has, you know, rules that, you know, take into account the growth that the committee is going to see in the future. What we also tried to put in place was the YMG ambassadors, who are representatives for the Chartered Institute of Arbitrators, but in areas where CIArb does not have a branch or a chapter. We also increased interactions between the different YMG branch chairs with the global steering committee, because before that, the branch chairs were doing their own thing and the global steering committee was doing its own thing. So now there's a way for the two parties to communicate. And then we also have a social media presence that is solely dedicated to YMG. Before that, we were relying on CIArb HQ to put out content for us, and also just let our members know what we're doing and our activities in place. And so what basically Anna and I did was do a lot of streamlining and put, you know, structures in place that will now assist CIArb YMG with now the larger diversity that they have and the number of members they have, to influence the work that we do in the smaller YMG branch groups?
Well, I think you did a very, very good job, you both. Congratulations. Yes. And well, turning to Anna. Anna, your resume shows that you have a lot of activities. So not only you perform your duties in arbitration proceedings, you work as a lawyer, but you also take part in a lot of initiatives like the task forces of ICC commissions and in the creation of the Rising Arbitrators group. And I also know that you're a mother. So how can you handle all of these activities?
Thank you, Cristina. It's a good question. And thank you, Noreen, for your kind words. Yes, I was very privileged to have Noreen as a chair. If I may add, she was been a fantastic chair, also a great leader and a courageous leader. So it was a pleasure. Yeah, so to say how I'm able to reconcile some institutional, let's say, activities and other activities of our profession. I think that I would say one has to be extremely organized and efficient because I have less time. I have less hours in my day for a good reason, because I have two children of a very young age, 3 and 1. So I would say, yes, being organized and very efficient. Also, it's important to have a good sense of priorities because and to learn to say no sometimes, because one can't do everything well. And I'm someone that if I say yes, I will do it well. Otherwise, I prefer saying no. Or if I'm to accept something, then it's best that I'm very active. Otherwise, I prefer not participating. And that I have been listening to. Also, I have good advice from my husband, who has been also, he's very active in his career. He's not a lawyer. And he always tells Anna, you have to focus because I have less time. I have to focus, and especially on the jurisdictions which are relevant for me. So that is probably the secret, or not a secret. It's just probably obvious.
Thank you, Anna. Cesar, please.
Thank you, Anna. And well, I take your words very seriously. Those about learning to say no and focusing, and those are extremely important things because today there are so many different opportunities all over the world. If you decide to attempt to take all of them or to take many of them, you're just lost. And so, yeah, those are very important advices. And well, before we close, I would like to just hear both of you on a final topic. It has to do with something that Noreen mentioned a while ago about your work at the YMG and the growth of the committee and how diverse it became. We all know there is a great deal of concern that the pool of arbitrators should grow and be more diverse. And age is always a factor. Alongside gender, race, geography, to name just a few. And from your experience at the YMG, the Young Members Group, what is really effective to promote age diversity among decision makers? What is your view on the efforts to promote diversity in general as well? Maybe we can start with you, Noreen, and then Anna.
Yeah, it's very interesting, this age issue when it comes to international arbitration, because a couple of the reports that we have seen, especially from the ICC, shows that the average age of arbitrators they appoint is 56. So, for instance, for me, I'd need at least another 16 or something years before the ICC recognize or are able to give me an appointment. So there's that issue where senior practitioners are thought to have more knowledge or probably wisdom when it comes to delivery of awards or just in the arbitration space. And yet studies have shown, and there's a study, I think, by Dr. Stacey Strong that shows that as we grow older, we do not change our reasoning. So there's actually no logic for us to appoint older practitioners as opposed to younger ones, because our reasoning really doesn't change throughout the years. We may, of course, gain a bit of experience and some wisdom, but ultimately our reasoning stays the same. And that, of course, is just a reason enough to for institutions to realize that they do not have to appoint the older arbitrators or older practitioners in their matters, or even as counsel. What I have seen effective, particularly with institutions, is for them to have a reserve list that accommodates practitioners either who have not started as arbitrators before or are still new in the profession. And each time they're asked to appoint a tribunal, they ensure that they pick someone from the reserve list to sit with the experienced arbitrators, so that they can now learn and even gain experience. We have the same in CIArb Kenya for our domestic arbitrations. We have a rule of neutrals and another rule of honor, where new practitioners or members and fellows are listed on that list. And every time someone needs to be paired up, or a tribunal needs to be set up with an older or more seasoned practitioner, both parties are paired. The other thing I think that might be important is for institutions to also have granular data of the practitioners that they appoint or the arbitrators that they appoint, so that it's very clear where the gaps are, what incentives and policies we need to do, but also what progress we are making, because we can have this discussion, but we're not really making progress. But if we have granular data from these institutions, we're able to see, okay, these are the number of young arbitrators we appointed last year, or who appeared before, the kind of appeared in matters that have rules with the different institutions, and what we can do better.
Thank you, Noreen. And it's very interesting what you said about this granular data. The lack of empirical data many times is a difficulty in promoting progress. And on the other hand, the transparency of those data creates some type of public awareness of the situation that in itself is a drive to change, right? And so it's very important to have that data, to have those data, and to make them available and make them public. Thank you. And Anna, would you like to comment?
Yes, I tend to agree with Noreen, and I would just add one thing. I think to promote age diversity, one needs to give opportunities at a young age, because in any case, one thing is reasoning. Also, one thing that is required from arbitrator is case management skills. And one can only be an excellent arbitrator if one has been exposed to this experience. So to promote age diversity, one has to also promote giving opportunities at a young age. And so that one can offer the right tools to young practitioners to perform a good mandate as arbitrator, because without opportunity and experience, it cannot work, because parties expect excellent management skills also, not only, of course, legal skills, but also like one has to handle the proceedings and be brave enough to decide, not decide too swiftly sometimes, just have sometimes good to sleep on it and the next day. But it's very important to be agile and take good decisions, not to please the party necessarily, but because one ends up not displeasing both parties if one does that. But this is like skills that are acquired through acting as counsel or acting as secretary to tribunals, or at an arbitral institution, seeing how from the background how it works. And I think that probably helps a lot if one becomes an arbitrator, and then one can become an arbitrator being very confident that one masters the skills. Otherwise it can be a stressful especially job, because very often young arbitrators are appointed as sole arbitrators, or in cases, the small cases where parties, sometimes there are defaulting parties and sometimes counsel is not as experienced. So it requires a bit extra, savoir-faire and, as I said, case management skills. And of course, it's good to also have good mentors. One doesn't need to give details, but sometimes good to discuss with people that have more experience than you.
Yeah, that's very good, and it's just interesting how it's, at least in domestic cases, in small cases, it's often the case that our institutions will appoint younger arbitrators for those positions. And as I said, many of those cases are very complicated because they have all these inherent difficulties. And the awareness, I think, of those difficulties is important so that our arbitration institutions can provide support to these younger arbitrators, maybe having some type of like group of more experienced arbitrators available to discuss with them things related to case management, for instance. And so I think the awareness of that is very important in the notion that institutions play a role in developing a larger pool of arbitrators and in promoting diversity. And thank you so much. Well, we have come to the end of our time. It's unfortunate that we cannot go on for much longer discussing with you, because that would be wonderful. I would like to thank again Noreen Kidunduhu. Is that how I say your last name? Perfect. Okay. And Gerdau, Borja, Mercereau. And it's been a pleasure having you here again. Thank you, Cristina, for the partnership. I would like to thank once more Arbitration Channel in FBonassa Advogados, our sponsor, and invite all of you to our next episode, which will be on March the 1st, relating to arbitration with state parties in Brazil. We will have with us two of the most prominent federal government attorneys in Brazil, involved in state commercial arbitration in Brazil, and that will be a good opportunity to discuss this topic. And also, I would like you to visit the CIArb Brazil Branch website and Arbitration Channel website to learn more about one very interesting program that we will put together on March the 8th with Vismut round, a demonstration round between Brazilian university and a team based on ChatGPT, artificial intelligence software. And so that we will have this human versus machine dispute, and that promises to be very interesting to watch. So I would like you to all to be there and witness this, which seems to be the first in the arbitration world so far. So thank you again, and see you next time. Goodbye.
Bye-bye. Thank you, Noreen. Thank you, Anna.
Thank you. Bye.
Bye. Thank you.
Bye-bye.